Welcome to another episode of the Criminal Law Department Presents podcast, a production of the Criminal Law Department at the Judge Advocate General's Legal Center and School in Charlottesville, Virginia. Every 2 weeks, we release a new episode. Today, we're going to have a conversation about a recent opinion from the Court of Appeals for the Armed Forces. Please note that these episodes may contain facts and circumstances surrounding criminal trials. Listener discretion is advised.
All rise! Hear ye, hear ye, hear ye. The Honorable United States Court of Appeals for the Armed Forces is now open and in session. God save the United States of America and this honorable court.
Hello and welcome back to another episode of Criminal Law Presents CAAF Chats. Today we're going to talk about United States v. Swisher, which was argued on April 17th, 2024 and decided by CAAF on July 11th, 2024. I am Major Dustin Morgan and I'm joined by
Major James Barrett. How are we doing today, Dustin?
Good. I'm glad to be back. So, James, what happened in Swisher? What's going on here?
So, Swisher is a sentence appropriateness case, and it's important to orient the audience to the law that we're dealing with. This is I want to, as time gets on, it's going to be the old Article 66, so it's going to be the pre-Article 66 version that we have going on now. And so we're talking about sentence appropriateness when a co-accused, in the rare instances, has a similar related offense and they've been sentenced separately. And in Swisher, we have a military accused and a civilian accused. Now, both individuals were accused and convicted of sexually assaulting a civilian female. The civilian pled guilty in civilian court. He pled guilty for sex offender registration. He received 5 years confinement, but that was suspended and had to serve 3 years probation. The accused Marine pled not guilty and was found guilty of sex assault and attempted sex assault and wrongful use of cocaine. He received a dishonorable discharge, 54 months confinement, which is basically 4.5 years, and a reduction to E1. He chose military judge alone sentencing. When his case went up on appeal at the CCA, the accused tried to say that it was error for him to receive such a disparate sentence from his civilian counterpart. The CCA said that they're not aware of any requirement to do so, and the CCA's position was basically, when comparing a co-accused sentence, this is a question of could versus must, and they chose the could route. So, CAAF went ahead and granted the petition, and they granted on, did the lower court err by applying the wrong legal standard to the sentence appropriateness analysis? And the CAAF reviews a CCA's sentence appropriateness determination for an obvious miscarriage of justice or an abuse of discretion, and that's what's going to be key for this case, because an abuse of discretion is, in a court's decision, is influenced by an erroneous view of the law. And so on appeal, Swisher said that the CCA had an erroneous view of the law and that they had to go ahead and compare his sentence with the civilian case. Now, it's back to my Article 66 analysis. This has to do with what should be approved under Article 66. So a CCA, when they review a case, have a sua sponte duty to make that review under the old version of the Article 66 that was in play. CAAF acknowledges at the outset that, generally speaking, neither Article 66 nor our precedents require the CCAs to engage in a sentence comparison with specific cases. However, CAAF goes ahead and points out that CCAs are required to engage in sentence comparison in those rare instances in which the sentence appropriateness can be fairly determined only by reference to disparate sentences adjudged in closely related cases. And in this case, CAAF said that, yes, this is that rare case where you have to do it. And so CAAF says the CCA must do the analysis. However, the analysis initially is on the accused to show that their case is closely related and that the sentence is highly disparate. Once the accused has shown that, or the appellant in this case has shown that, then the burden shifts to the government to show that there is a rational basis for this disparity. It's important to know that the CCA is required to make these determinations, but they did not do it in this case. And because they did not do that, CAAF goes ahead and remands this back to the CCA to make that initial determination. Now, CAAF did talk about what the appropriate remedy is. CAAF remanded this back for 3 reasons. They said it's been done before, that the sentence appropriateness is a CCA job, not theirs, and that the parties agreed that if this was the case, that it should be back. And so CAAF went ahead and affirmed the findings, but set aside the sentence portion of the CCA decision. And so essentially, what the CAAF is telling the CCA to do is to make that initial determination about whether the accused has met their burden of whether the cases are closely related and whether the sentences are highly disparate. And then the burden will then shift to the government to show whether there's a rational basis for this disparity. I will note that between the dissent and the accused, the majority, the dissent, and the government, one of the points of contention was that this was a Marine within the civilian jurisdiction. And they said that that was not dispositive and that was merely just a factor to use when determining whether there's a rational basis for that disparity.
Yeah, interesting stuff going on here. So just several things to look at. So first, the appellant's saying, hey, my co-accused who did the same thing I did, same exact crime if you look at it, they're just co-accused together, just in different jurisdictions, more or less. He got a 5-year suspended sentence, which means he doesn't serve a day in prison.
Correct.
And I got 4.5 years.
Yeah.
So alarm bell should be going off just from that fact alone. Like, different jurisdictions should not mean that much of a difference. The CCA just hand waves that. They're like, well, this isn't just a small difference. This is a completely different jurisdiction. They're obviously not closely related. We're not even going to do that comparison. And then ultimately CAAF is like, well, you can't just hand wave it in total. Just because it's a different jurisdiction doesn't mean you don't do that analysis. That's fundamentally what's going to have to happen.
And one of the things you're starting to see, I think, from CAAF, and I think the field should take note, is they are doing a elements analysis. They are comparing element by element by element, and you see this in a lot of cases, not just Swisher. You're seeing this more in preemption cases, multiplicious cases. They are getting out the pen and paper and literally writing down the elements of the statute. And they did that in this case. And so it's very important, if you're in the field, whatever issue you're dealing with, is to actually break down these elements. I will say also, lurking in the background of this case, the takeaway for the field here is some people have heard of the Friedman instruction, and that's out of an Air Force case, United States versus Friedman. But essentially, an accused has the ability to say whatever they want in their unsworn. There's some guardrails, obviously, but for general practical purposes, an accused during his unsworn has the complete right of allocation. And when the accused does that, the military judge will give what's called the Freeman instruction, particularly when they stray into matters that they should not be straying, that are irrelevant, and say, hey, panel, disregard this completely. And so when you're looking at co-accused with disparate sentences, there's an accused who will want to say, hey, my co-accused got nothing like what the government wants to give me in this case, or sentence me along the same lines as my co-accused in these cases. A judge will tell the panel, hey, don't consider that, or a judge will tell themselves, I'm not going to consider any of that, because again, it's hard to imagine how this is as relevant under RCM 1000D for the defense, either under mitigation or extenuation. And so, what does that mean for a defense counsel out there? Do you just hand wave this and not do it? Well, one, I think you chock full the post-trial documents with all of this, because this is a sentence appropriateness issue. And nerd out with me for a second, Dustin, but Article 66 has changed, and we've got plainly unreasonable now for the sentence. And so it's going to be interesting how a co-accused sentence makes it plainly unreasonable as we go along, as the CCA does their sentence appropriateness review.
Yeah, that should word, that should be approved standing by itself. We saw the power of that in the old 66. I mean, not just in sentence appropriateness, but in factual sufficiency review.
Or waive all motions provisions with United States versus Chin, piercing that. So it's going to be very interesting to see how that plays out.
So that removal of one word, or that changing that one word, probably has huge ramifications and huge repercussions for at least the appellate practice going forward. But you're right, this is just an appellate issue, because in the past, practitioners, I'm sure you did this in your defense counsel too, even if you get the Friedman instruction, or if you get something like a talking to instruction where your client would talk about sex offender registration, you knew that instruction was coming, but oftentimes you didn't care, just wanted the panel to hear it. But we're judge alone sentencing now.
That's the thing is post 27 December 2023, you're only at a judge, and a judge is going to say, I presume to know the law, and you may get a judge that says, when arriving at my sentence, I did not consider any inappropriate evidence or argument from counsel.
So, I mean, this is a pure appellate issue. So you're right. As we kind of always talk about when we're in this realm, it's build the record, build the record, build the record, build the record. You have to show the appellate courts how they were similar cases, but disparate results. Here is a pretty good test case for it if you're just looking at it.
And remember, do not conflate relevancy and admissibility for sentence purposes under RCM 1001, and then also what you can submit as post-trial documents to the convening authority or the appellate courts to consider. So it's a multi-tiered, multi-realm fight that both parties and the government need to be aware of. So if you're a chief of justice and you get these documents, it's not a wholesale denial. You understand why they're coming from. And if you're a defense counsel, you're not just stopping at, hey, this isn't fair. You're actually putting in statements from other people. If you have the police report, you're putting that in, court documents from the co-accused cases and the like.
Yeah, give the appellate courts the ammunition to do this elements analysis like James is talking about, for them to be able to go back. These are similar, disparate sentences. Maybe you get a better result for your client at the end of the day. But
at the end of the day, also, Swisher is a very, very rare instance, the unicorn of cases. Don't expect these to pop up too much.
No, just the fact that civilians took a case that's similar like this is rare in and of itself. So I mean, you don't see this too often.
Yes.
Okay. Anything else on this one, James? Or
no, that's all I got.
Yeah. So interesting appellate case. Something to glimmer for the trial practitioners out there. Thanks again for listening. We appreciate you as always. And until next time.
Thanks for joining us today for another episode of the Criminal Law Department Presents podcast. If anything you heard sparked a thought, we'd love to connect with you. Your comments help us create better future content for the field or the fleet. Reach out to us on Facebook or Instagram. The information can be found in the show notes for today's episode. The views expressed in today's podcast are those of the presenters and not necessarily the Judge Advocate General or the Department of the Army or the Department of Defense.
Thanks, counsel, for both sides. And the court will stand in recess until further order of the court.